Motion, Mr. Stokes, is there anything you would like to add before we hear from Miss Nick?
My son, for some reason, and I knew about this, well, without me having any kind of consent, he's in Florida right now. There's a parenting time order in place. She has not followed that at all, not whatsoever. That's why we're at where we're at right now. But I don't know his whereabouts. She had let me know that he has a phone number that I could contact him with. However, now I'm blocked from that phone. I have no idea why. There's nothing going on, but I cannot call my son. I cannot get a hold of my son. I cannot communicate with my son. This kind of started back in December. It's slowly progressed into now I just can't have contact with my son, according to Miss Nink. So it goes beyond maybe having a parenting time order revised, but I'm kind of looking at like she's in contempt. She hasn't let me see my son. He's in Florida. She said I had to go to Florida back. My brother-in-law broke his hip. I had to go back to Florida and kind of help with him in Punta Gorda. And she said at the time that she was the first person I called to let her know about this. She was fine with it because he was going to be going to Florida to his mother's house and his mother's boyfriend's house. Well, he's there. She dropped him off, went there for 3 days, and now he's supposedly going to be there till August. And she just basically didn't ask me. She told me. And he's there. I can't contact him. I don't even know where he's at, what town, anything. Okay. And then it changed. All of a sudden, I couldn't go and see him or pick him up in Florida and spend time with him because we had a big event that we were going to spend the summer, in Florida, And then, so I came back so I could file these motions. And my brother-in-law is getting well now. And, well, I'm back and I need to take care of this and get this resolved because what she's doing, everything she's doing right now is the definition of alienating him from me and separating us. And now he is a little bit spooked and weird. He's on Adderall, and I would like to know why he's on Adderall. I do not know why he's 9 years old. She's got him on pills. She does not inform me of absolutely nothing. She does not communicate with nothing. And this is a problem. We have a very close relationship. We had, and it's slowly, to her benefit, disrupting it is in every way she can possibly do this.
Does at least according to my information, the judgment of paternity was entered on the 17th of November of 2016, which granted custody to plaintiff mother.
Yes.
So you don't have any type of custody which would require her to get advanced approval for such things as doctors, medication, trips to Florida. What is your current parenting schedule?
We had a parenting time schedule that was in 2016 when he was 5 months old. I had to go and get it in front of Judge Denenfield for that because she wouldn't let me see him. That was in probably November of 2016, but it was still in place. We have not updated it because we always agreed to meet in Nunica at a place called Turks. That was like our drop-off pickup spot, and it wasn't really much of a problem there. And then it slowly just turned into what is in her benefit that I can see my son. Okay. And I'm really I'm in the dark in all this. And she's telling me my son doesn't want to talk to me no more. Well, my daughter wrote a statement, and I wanted to hopefully get in front of the judge after this. I don't want to see a referee.
Well, let me stop you a second.
Okay.
You don't get to make that call. All right. No, that's not your call one bit. In fact, I can pretty much guarantee it's going to stay here with me. So if that's a problem, then either you're going to have to get used to it, or you're going to have to file your own motion in front of Judge Gottlieb and convince her that she should hear this. And not.
Here's a reality check a lot of litigants learn the hard way. You don't get to choose the judge, the referee, or how your case is heard. Court procedure is not negotiable. The judge shuts this down fast to reassert authority and keep the hearing on track. This isn't personal. It's about order, efficiency, and making sure emotion doesn't derail the legal process.
Not her referee. That's the first. The second thing, what is your current parenting time schedule?
I would see him. The schedule was at that time I was only getting 4 days off a month, and I got him both those days every other weekend.
Is that what the order says?
Yes.
Okay.
Yes, I met him in Hudsonville. Her in Hudsonville. This is when I lived in Holland. She moved to Grand Rapids. We met in the middle there. Since then, it's changed, but it's still in place.
Okay. Let me chit chat with Miss Nate. What's going on?
Hi there. Yeah, like you said, I have full custody. Our original parenting time was we talked to a mediator and we agreed that we would meet in Hudsonville. Like he said, he lived in Holland. I lived in Grand Rapids. It was our halfway spot. It worked well for both of us for a while. I'm not sure what the original agreement said. I think it was a couple days a week and maybe one overnight at that point because he was pretty young. We changed it to work with Jared's schedule. I said he could do every other weekend. He kept switching up his weekends and stuff. We continued to do that for a while and it did okay. Then he lost his apartment out there, lost his job. Now he lives an hour away at his mother's house when he's there. So I agreed I would meet him in Utica, which is about halfway. We were doing every other weekend for a while. A couple times my son did not want to go. He said he didn't want to be around his dad, that he was a jerk, stuff like that. He wouldn't really tell me what happened. He just said his dad was mean and he didn't want to go there. So I'm not going to force him if he doesn't want to go. Like you said, I have full custody. I will work with Jared if it's in the best interest of my son. He knew about the Florida trip ahead of time. I did tell him he's been in Florida almost this entire year. I have proof of this. He is the one that has not been seeing his son. It is not me. And I even arranged to visit with him right before Noah went to Florida. And he comes home the end of July. Jared is aware of this. He did see him the weekend before he left. And I did get him a phone so he could talk to his dad while he's away. If he isn't talking to him, it's because he doesn't want to. He's 9. He's old enough to make his decisions.
No, he's not. Let me correct you right now.
Okay.
No, he's absolutely not. And to the extent that you have relayed that, that stops now. Okay. 9-year-olds don't drive the bus in my courtroom, period. They are not, absolutely not, going to make decisions about, I don't want to go to my dad, so that's that. Because 9-year-olds don't have the ability to comprehend things. It's like when they say, I'm not going to school. Okay? What you do is you put the kid on the bus. That's what you do. Now, granted, when the kid gets 19 or 16, 17, it becomes a little dicier. But but 9-year-olds do not. They're not old enough to make that decision. And they will not make that decision with me. Okay.
I understand, Brenner. Can I explain that further? I'm sorry, I didn't.
No, you don't have to. I got the picture. The one picture I do have is that the two things I'm going to do today. One, I want your son's phone unblocked from Mr. Stokes.
It's not blocked.
Okay, then
Yes, it is.
Stop, you two. How am I going to figure this out? You say yes, you say no. To the extent it's blocked, it gets unblocked, and Mr. Stokes is allowed reasonable telephone contact with your son. That's number one. The second thing is, I can't decide this on a Friday morning. I am going to find, pursuant to Shade versus Wright, 291 Michigan Appeal 17, a 2007 or 2010 case, that poor communication and lack of cooperation between parents, which is clearly going on here, does constitute a change of circumstance to revisit parenting time. I'm going to respectfully deny the motion to change custody. I am going to reopen parenting time, however, because
This is where law overrides emotion. The judge cites Shade versus Wright, establishing that poor communication and lack of cooperation can qualify as a change in circumstances, but not enough to change custody outright. So custody stays the same, but parenting time is reopened for review. This is a measured ruling, protects stability while addressing legitimate concerns through the friend of the court investigation.
Been a lot of changes going on, and we will Are you working currently, Ms. Nink?
I am, yes.
Mr. Stokes, are you working?
No, I am not, Your Honor. I was laid off from my job. I just came back from Florida. I will be going back to work, though.
Okay.
How much money did I make her? I'm fine. My brother-in-law broke his hip. It was a family emergency. She was well aware of it. We had plans for him to come with me this summer to Florida, and then she just all of a sudden.
Do you see what the problem is, Mr. Stokes?
Yeah.
Let me just stop.
I'm upset is what the problem is.
Well, that's good that might be good, and it might be cathartic, but you have just spent 3 minutes detailing things that I didn't ask. The only thing I asked was, are you working? That's it. Okay. And you indicated you're laid off. All right. So, I still think you can get your hands on $150. So I am going to send this to the friend of the court for an investigation and recommendation. The fees for that will be split. And we'll see what they say. And if they come up with a recommendation that the parties can live with, they sign on to it. If there's an objection, be very careful. You can't object because, it just does, you wish you had more. Well, it doesn't work that way. So we'll find out once the friend of the court gets things settled. But I want his phone unblocked, and I want Dad to have reasonable telephone contact. That starts now. And just to the extent anybody was saying that, 9-year-olds are not old enough to make their own decisions, period. I make them, unless the parties want to, but I have to make them then. So you're both all set. I'll do the order of reference today. Make sure the friend of the court has your correct information so they can tell you.
I'm gonna have legal consultation after this. Probably represent this matter of a friend doing pro bono. Just to help me out because this isn't how this is only me having a relationship with my son to her when it's convenient for her.
Yeah, we're trying to unwind that, Mr. Stokes. So you're just going to have to be patient and let us unwind it. And I don't care if you come in here with F. Lee Bailey. I would do the same thing. Okay?
I understand. Yes, I understand, sir.
I try and treat everybody the same, attorney or no attorney. But you're all set. The one thing I just want you to work on is, please, when I ask you questions, just answer the question directly and don't go off on these. I know you're upset, but it's important that we stay on focus here, okay?
Yes. You're absolutely correct. Okay.
Thank you. We're adjourned.
And we're going to be splitting that. We're going to be splitting this, you said.
$150 apiece.
All right. Sounds good.
At the end of the day, this court didn't reward either side. It corrected the process. Custody remains unchanged, but communication failures forced the court to intervene, restore phone contact, and reopen parenting time. The bigger takeaway? Family court runs on orders, not assumptions. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.